Staying in our courts now, the Johannesburg High Court has reserved judgment in a matter of convicted killer Donovan Moodley. The 43-year-old is asking the court to set aside the parole board's decision in March, declining his parole bid. Moodley was convicted in 2005 for the kidnapping and murder of Bond University student Leigh Matthew. His lawyer argued earlier that the parole board's decision was questionable. Nqobile Madlala takes a look.
This is Donovan Moodley. He's currently behind bars for the 2004 murder of Leigh Matthew. He was convicted in 2005 on 3 charges: a life sentence for murder, 15 years for kidnapping, and 10 for extortion. The family paid a ransom of 50,000 rand, and yet Leigh was fatally shot 3 times. In March 2023, the parole board decided that Donovan did not qualify for parole, arguing that he still needs more rehabilitation.
The applicant must undergo individual psychotherapy with a psychologist. Secondly, the recommendation is made that the psychologist has also been asked to address the abnormal love of money which the offender has displayed throughout his life.
Moodley is now seeking the court to put on review and set aside that decision by the parole board.
Are we going to remit it back to a further parole board? We would argue against it being remitted to the same parole board for obvious reasons. There's 2 attempts. I don't think there's reason to go for a 3rd attempt. So we would be arguing for the contention that this court can substitute that decision.
It was further revealed in court that Leigh Matthew's family was also concerned about how the matter was handled. The family representative mentioned that they had more arguments they wanted to present to the parole board, but wasn't able to put on record. Friends of the court have suggested a retired judge hear the parole decision review application.
Our submission, my Lord, is that no one can go so far as to say as to whether there should or should not be a recommendation that he should or should not get parole to the minister. Submission is that he should be not cast into that hole, but given a fair hearing before somebody who's not tainted and who has the qualification and expertise and experience to hear it.
The state has argued that the parole board had in-depth information from both the applicant and the family.
What we need to accept as common cause is that the same profile that was used in the application that was set aside and the one that is applicable in the current matter are basically identical, save for 2 additional documents which Mr. Moodley has raised regarding to the issue of anger management, and then the other one relates to the dates that are put, wherein it's the same thing with a different date.
But the parole board's flaws couldn't be denied.
We have the sleeping of one of the members of the parole board. We have a concession now that Mr. Moodley's lawyer was shut down. Isn't that enough on its own to vitiate these proceedings?
Judgment in the matter was reserved. For Newzroom Afrika on channel 405, I am Nqobile Madlala in Johannesburg.